This presentation relates to our consultation paper, Getting Married, a consultation paper on weddings law. We published the consultation on the 3rd of September, and we're now running a public consultation on our provisional proposals for reform until the 3rd of December. I'm Nick Hopkins, the Commissioner for Family Law, and I'm joined for this presentation by Professor Rebecca Probert, the expert consultant on the project, and by Elizabeth Welsh, the Law Commission's lawyer who is working on the project. This presentation is aimed particularly at independent celebrants. By independent celebrants, we mean celebrants who are not affiliated either to a religion or to a non-religious belief organisation. And in this presentation, we highlight aspects of our provisional proposals that we think will be of particular interest to those people. So, for example, the content of wedding ceremonies and who is able to conduct wedding ceremonies. If you're not familiar with the Law Commission, we were created by Parliament back in 1965, and Parliament gave us the job of keeping under review the law of England and Wales and making recommendations to government for reform. We act within terms of reference for projects that we agree with government, and having agreed those terms of reference, we operate independently from government in drawing up our recommendations for reform. If you want to know more about our relationship with government, it is set out in a protocol that you can find on our website. Turning now then to our weddings project. Some of you listening to this presentation may remember that in 2015 we published a scoping paper called Getting Married. That scoping paper did not set out provisional proposals for reform, but it identified the issues that would need to be addressed in a review of weddings law. In the budget in 2018, government then asked us to go ahead and do a law reform project on weddings law. And we began the project in July of 2019, having agreed the terms of reference for the project with government. And it's this work that has led to our consultation paper. Under the terms of reference that we have for the project, we have agreed to make recommendations to government to reform weddings law that will allow couples greater choice within a simple, fair and consistent legal structure. Our review is guided by 5 principles for reform. We want to make the law certain and simple, and also provide fairness and equality. We want to protect the state's legitimate interests in weddings law. So, for example, the state's interest in knowing whether a couple are legally married and in protecting against forced and sham marriages. We want to respect individuals' wishes and beliefs in relation to their weddings. And finally, we want to remove any unnecessary regulation. The terms of reference for our project require us to look at all of the legal formalities relating to a couple getting married. And so we look at the preliminaries or the giving of notice for a wedding. We also look at where weddings should be able to take place, and so we have provisional proposals that would enable weddings to take place in a much greater variety of locations, for example, outdoors and on cruise ships. We consider who should be able to solemnise a civil or religious wedding, and how the law could allow for weddings to be solemnised by non-religious belief organisations and by independent celebrants. The questions of whether members of non-religious belief organisations on the one hand and independent celebrants on the other should be able to solemnise weddings is not, however, part of our review. We consider whether specific vows should be required during the ceremony and generally what legal requirements should be imposed in relation to the ceremony itself. We look at how marriages are registered, and we look at the consequences where the legal requirements are not complied with. So, for example, the consequences for the validity of the marriage. There are also some policy assumptions that underpin the work we're doing. And so our project proceeds on the basis that religious groups will continue to be able to marry people as they can do now, as long as certain conditions are met. The definition of religion for these purposes will remain as it was decided by the Supreme Court in 2013. If independent celebrants or members of non-religious belief organisations are able to solemnise weddings, then our project works on the basis that they will not be able to discriminate between opposite and same-sex couples. There are also a number of matters that are excluded from our project, and so these are matters that we haven't made provisional proposals about and that we will not be making recommendations for reform in relation to. They are the eligibility of parties to get married, so for example the age at which parties are able to marry. The ability of religious groups to not solemnise same-sex weddings, that's protected under the current law, and it will continue to be protected under any recommendations that we make. The duty of the Church of England and the Church of Wales to marry parishioners will also be unaffected by our recommendations. We are looking only at the legal process of getting married, and so our review does not go further to consider the rights and responsibilities involved in being married, or indeed what happens if a couple divorce. Nor are we looking at the recognition in England and Wales of weddings that take place overseas. And finally, our review does not look at ancillary wedding services, for example, contracts for catering that a couple may enter into when they get married. So with this in mind, we have put forward a provisionally proposed scheme for a new law of weddings. Under the scheme we have put forward, it would replace the outdated, overly restrictive current law of weddings, much of which dates from 1836, and that contains restrictions on how and where a couple get married that seem to us to exist for historical reasons rather than reflecting current policy principles. Our proposals would make the law simple, fair and certain. A key feature of our provisional scheme is that it focuses regulation on the officiant, that is a person who would have certain legal responsibilities in relation to the wedding, rather than, under the current law, the location or the building in which the wedding takes place. And as far as possible, our scheme would apply the same rules to all types of weddings. Now, depending on the size of screen you're looking at, the infographic in the slide may be very legible to you, or it may not be particularly visible, but it's available in our consultation paper and in the summary of that consultation paper on our website. And what it shows is the path towards marriage from the point of view of a couple under our provisional proposals. As under the current law, the path to marriage is divided into three distinct stages. The preliminary stage, where notice of the wedding is given, the ceremony itself, and then registration. But we believe that under our provisional proposals, these three stages will be much more simpler and clearer for parties to navigate, and will give them much greater choice to have a wedding that is meaningful to them. So I'm now going to hand over to Rebecca and Elizabeth to take you through some of our key provisional proposals.
Thank you, Nick. So first of all, we consider who's responsible in relation to each wedding, usually considered in terms of who conducts the ceremony. Under the current law, only religious groups and registration officers can conduct weddings, and these rules are both complicated and unclear. First, there are issues about inequality. The Marriage Act 1949 essentially categorises weddings into 5 types: Anglican, conducted by the Church of England and the Church in Wales; weddings by Jewish groups; weddings by the Society of Friends, weddings by all other religious groups, and civil weddings, which are then subdivided with slightly different rules into weddings in the Register Office and weddings on approved premises. There are different rules for these different categories in terms of who has responsibilities in relation to the wedding. For Jewish and Quaker weddings, although there are rules about how the wedding is registered, there's no requirement for anyone in particular to attend the wedding. For Anglican weddings, however, a clerk in holy orders must be present. And for all other religious weddings, a person authorised to register the marriage, who is authorised for the registered building, must attend. And in their absence, a registrar must attend the wedding. For a civil wedding, 2 registration officers, the superintendent registrar and a registrar, must attend. There are also different rules which govern what the person required to attend the ceremony must do, resulting in a lack of clarity. Most consistently, they're only required to register the marriage, but some have additional roles. Anglican clergy, for example, are also required to solemnise the marriage. And there's also a difference in treatment as to how a person can be approved to have this role to register a religious marriage, depending on the religious group. For an Anglican wedding, it has to be a clerk in holy orders. Those responsible for registering Quaker and Jewish weddings are appointed by organisations that are specifically named in the legislation. This is a rather top-down approach for these organisations, who can choose not to certify a particular person, therefore preventing certain groups from conducting a Quaker or Jewish wedding under those provisions of the Act. For all other religious weddings, the group must have a registered place of worship. After a year of registration, they can appoint an authorised person to be responsible for registering marriages. During that first year, or otherwise in the absence of the authorised person, a registrar must attend the weddings conducted in that place of worship to register them. The current law also suffers from unnecessary regulation. In particular is the requirement for a registrar and superintendent registrar to attend all civil weddings. This increases cost for local authorities and for couples, and limits the availability of weddings at particular times, such as during the summer. So we propose a system that rationalises these requirements. Under our scheme, there would be a new role of officiant. All officiants would have the same legal duties and responsibilities, and all weddings would have to be attended by one officiant. The focus of the regulation would be on this person and their responsibilities. Now, there would be up to 5 categories of officiants, depending on the decisions made by government on the point of whether non-religious belief organisations and/or independent celebrants can conduct weddings, a point on which we're not making recommendations. Registration officers would conduct civil weddings. Only one would be required to attend, and they would no longer attend religious weddings. Anglican clergy would conduct Anglican weddings. Nominated officiants would be individuals or office holders nominated by religious organisations other than the Anglican churches to conduct religious weddings. And if non-religious belief organisations are enabled to conduct weddings, nominated officiants would also be nominated by non-religious belief organisations to conduct non-religious belief weddings. Maritime officiants would conduct civil weddings in international waters on board certain types of vessel. And if government decides to enable independent celebrants to conduct legally binding weddings, celebrants would be able to apply to the Registrar General to be authorised as independent officiants to conduct civil weddings. In this case, they would apply directly to the General Register Office for authorisation and appear on the public list of officiants. Independent officiants would be authorised to conduct civil weddings, not religious or non-religious belief weddings. In order to be able to be authorised, an independent celebrant applying to be an officiant would have to be a fit and proper person. For independent officiants, this standard would expressly require them to be at least 18 years of age, to understand the legal requirements of being an officiant, and have undertaken prescribed training. This would be either provided by the General Register Office or approved by the Registrar General. Of course, many celebrants have already undertaken training. However, the required training under our provisional proposals would focus on how to ensure that the relevant legal requirements were observed, rather than on the ceremonial aspects. So it would be necessary for all independent celebrants, even those who might have conducted legal weddings in other countries. Independent officiants would not be required to be a member of a professional celebrant organisation or to have insurance as a matter of the law. However, in practice, these types of organisations might be able to provide training to celebrants, as well as support and other benefits, and so many independent officiants might choose to be members. But again, it would not be a legal requirement. Once authorised to conduct legally binding weddings, independent officiants would be prohibited from acting with a conflict of interest, in that they would not be able to use that role as a means of making money from additional services. The rule would therefore preclude independent officiants from requiring couples to purchase other services from them, or from receiving a commission for referring couples to particular providers of ancillary services, for example, a sister's floristry business. But it would not otherwise prevent officiants from charging a fee or making a profit from officiating at weddings. There would be no time limit on authorisation, but to retain their authorisation, independent officiants would be required to complete ongoing training as prescribed by the Registrar General. This training would focus on any changes or updates in the law, for example in relation to forced marriages. An independent officiant could not be authorised as another category of officiant. So, for example, they could not also be an officiant conducting religious weddings on behalf of a religious organisation. Under our proposed scheme, the different categories of officiants would be authorised in slightly different ways. Registration officers would continue to be appointed by local authorities. It would be up to local authorities to determine the requirements for the role, so the requirement to be a fit and proper person would not directly apply. Anglican clergy would be authorised to act as an officiant by virtue of being in holy orders, in recognition of the special status of the Church of England and the Church in Wales, and their duty to marry their parishioners. Nominated officiants will be nominated to act as officiants by their nominating body. And we ask in the consultation paper whether nominating bodies should be able to nominate officiants by office, so that all holders of a particular office at the organisation would be officiants. Now, a nominating body could be either a religious organisation or, if enabled to conduct legally recognised weddings, a non-religious belief organisation. To count as either type of body, the organisation would have to meet the definition of a religious or non-religious belief body, and also to have at least 20 members who meet regularly for worship or in furtherance of their beliefs, and have a belief about marriage or a wedding ceremony. The primary responsibility for monitoring would lie with the nominating organisation. Maritime officiants would apply directly to the General Register Office for authorisation. They would be required to be deck officers of certain vessels conducting civil weddings in international waters. We envisage that these would be cruise ships, but possibly other passenger vessels too. Otherwise, maritime officiants would be subject to the same rules as independent officiants. All officiants would have the same duties and responsibilities. For every wedding they conducted, all officiants would have the duty to ensure that the parties freely expressed consent to marry each other, that the other requirements of the ceremony were met, and that the schedule was signed. Officiants would also be responsible for upholding the dignity and solemnity of marriage. In devising these duties and responsibilities, we've considered all types of wedding under the current law, as well as the weddings that are not currently recognised, which are conducted by non-religious belief organisations like Humanist UK and by independent celebrants. And we think that this common set of responsibilities would work for all weddings. I'm now going to hand over to Elizabeth to talk about the content of the ceremony itself.
Thank you, Rebecca. So under the current law, there are concerns about the different restrictions that are imposed on weddings depending on the category of wedding made under the Marriage Act 1949. So, for example, civil ceremonies and religious ceremonies other than Anglican, Jewish, and Quaker ceremonies must include exact prescribed words. That is, the couple each must make a declaration that they are free to marry one another and the words of contract, following exact prescribed words in the legislation. Conversely, Anglican, Quaker, and Jewish ceremonies do not have to include these prescribed words. Rather, the legislation requires that those weddings take place according to the rites of those groups. Under the current law, there is also a restriction which prevents religious content in civil ceremonies, with only incidental religious references permitted. We understand from stakeholders from our discussions to date that this rule does not reflect the beliefs of many couples who wish to include content that has religious or cultural meaning for them in their civil ceremonies. The Act also requires some weddings to take place with open doors or with free public access. Again, this requirement only applies to some type of weddings, civil weddings and religious weddings other than Anglican, Jewish, and Quaker weddings. Again, however, there is a concern that this is not serving a clear purpose. For example, it does not, so far as we have heard, give rise to valid objection at the ceremony. Under a proposed scheme, the same legal rules would apply to all groups and to all types of wedding ceremonies. Under our provisional proposals, our scheme does not regulate the content of ceremonies more than is necessary to give couples freedom over their ceremonies. So as we explained in the consultation paper, under our provisionally proposed scheme, the core requirement of any wedding ceremony would be that each of the couple would have to express their consent to be married in the presence of each other, the officiant, and 2 witnesses. But there would be no requirement that they express their consent in any particular way, and consent could be expressed non-orally. Now, we think this will accommodate the many ways in which people show their consent to be married. Now, of course, religious groups, and if enabled to conduct weddings, non-religious belief organizations, could impose their own requirements about the ceremonies that they would conduct, including whose weddings they would conduct and the content of those ceremonies. Under our provisionally proposed scheme, religious content would be permitted during civil ceremonies, meaning ceremonies conducted by registration officers, and if government-enabled independent celebrants to conduct weddings, then independent officiants. So under our provisional proposals, although religious content would be permitted, the ceremony would be required to be identifiable as a civil ceremony rather than as a religious service. And we ask whether the legislation should expressly state that certain things would be permitted. For example, hymns, religious readings, imagery, and songs in a civil ceremony. And under our provisional proposals, there would also be no requirement for open doors for any type of wedding. So turning now to where weddings can take place. The current law is often described as a building-based system, in that under the current law, most weddings have to take place in a building that is either a registered place of worship, or a register office, or premises that have been approved for a civil ceremony. However, some types of wedding are excepted from these rules. Jewish and Quaker weddings can, as a matter of the civil law, take place anywhere, allowing those groups to themselves regulate where their weddings can take place. There are also distinct rules that govern Anglican weddings. So now, although most Anglican weddings take place in a public church or chapel and must do so, a wedding that is authorized by Archbishop's special license can, as a matter of law, take place anywhere. However, we understand that the Archbishop only issues such licenses for weddings in places of Anglican worship, for example, in private college chapels. So these rules, in addition to being complex, also limit couples' choice. For example, most couples cannot marry outdoors, they cannot marry in a private home, and they cannot marry in a lake or at sea. Many of the weddings that currently take place outside the legal framework, including those weddings conducted by humanist celebrants and independent celebrants, take place in a much wider range of places, which shows that there is a demand among couples to get married in a wider variety of places, for example, outdoors. The current rules are also unsuitable for some religious groups. Some religious groups, particularly small groups or interfaith ministries, tend not to have their own buildings in which they can conduct weddings. For other religious groups, their place of worship is not seen as a meaningful place for a wedding to take place, and we understand that this is the case for some Muslim groups. Some religious groups also worship outdoors rather than in a building. And if non-religious belief organizations were permitted to conduct weddings, these rules would not work well for them, as they also tend not to conduct wedding inside particular buildings. We've heard of the wide range of places where Humanist UK celebrants conduct weddings, and this is something that we have also heard in relation to independent celebrants and the weddings that they conduct outside of the legal framework. There are also concerns with the current law in relation to the regulation of civil venues, and in particular that they drive costs. So civil venues, other than register offices, must be approved by the local authority before a wedding can take place there. And our initial research suggests that local authorities charge a median fee of approval for an approved premises of £1,500. This cost can prevent businesses which only host a few weddings a year from being able to be approved. So under our proposed scheme, the regulation focuses much more on the officiant than on the location, and that gives greater freedom about where a wedding can take place. So as we explain in our consultation paper, we propose that a wedding should be legally permitted to take place anywhere, including outdoors, in a private venue such as a home or on a military site, and on inland, coastal, and territorial waters. Under our provisionally proposed scheme, there would be no requirement for venues to be pre-authorized by government, which would reduce unnecessary bureaucracy. However, we do ask whether civil weddings should be prevented by law from taking place in religious venues, such as places of worship. And if non-religious belief organizations weren't able to conduct weddings, we also ask whether their venues should also be places where civil weddings cannot take place, to the degree that non-religious belief organizations do have such venues. As we explain in the consultation paper, in order for a wedding to take place in a given location, the officiant officiating at that wedding would have to agree. The officiant would be responsible to consider the dignity and safety of the venue in giving their agreement, and officiants would be provided with guidance from the General Register Office on safety and dignity. Now, we think this approach would increase the choice for couples, allowing them to get married in the location most meaningful for them. An increased choice would also open up lower cost options, like getting married at home or in small community venues. And we also think that it would drive competition among businesses. Of course, religious groups, and if they were unable to conduct weddings, non-religious belief organizations, would be entitled to insist on their own requirements about where a wedding could take place. And so, for example, religious groups could continue to only conduct weddings in their places of worship if that's what they wished. We also consider whether there should be an optional scheme for pre-approval. And if there were, some venues would already have been determined to be safe and dignified, which would remove any need for an officiant to make that assessment on their own. And we think that this scheme might be most useful for registration officers, and potentially if they were authorized to conduct weddings, independent officiants might also find it useful. So now taking a step back and looking at our provisional proposals as a whole, this graphic, which again may look quite small depending on the size of your screen, so please do have a closer look at it. It's available in our consultation paper and in our summary. This infographic shows the rules that would apply to all wedding ceremonies under our provisional proposals. It shows each potential type of officiant and the requirements that apply to the ceremonies that they would conduct. And it illustrates that, with very few exceptions, the requirements for all wedding ceremonies would be the same. So what's next? Our public consultation on our consultation paper and our provisional proposals will run until the 3rd of December. After that, we will analyze what consultees have told us and formulate our policy. We will publish our final recommendations to government report in 2021. And we strongly encourage you to respond to our consultation, and information on how to do so is available on our website. Thank you.